5, 4, 3, 2, 1. The appellant joined the services of the bank as clerk-cum-godown keeper in the year 1961. After 12 years of service and after successful completion of examination and interview for promotion as an officer, he was promoted as an officer of the bank on April 16, 1973 to the post of accountant. He was further promoted to the post of manager in the month of September as branch manager, Pondicherry Branch. After 4 years of his service in that post, he was placed under suspension on March 25, 1981 on the basis of an inquiry in relation to contravention of norms laid down by the bank, and finally an article of charges dated February 25, 1983 was issued to the appellant, and he submitted his explanation on March 14, 1983. An additional charge dated May 26, 1983 was issued to the appellant. The appellant submitted his explanation for all the charges, but departmental proceedings were continued by appointing an inquiry officer. Before the inquiry officer, oral evidence was let in and the petitioner was interrogated and documents were filed on behalf of the bank. Written arguments were submitted on March 31st, 1983, and the petitioner submitted his defense on April 14, 1984. The disciplinary authority, on the basis of the report of the inquiry officer, the copy of which was not furnished to the petitioner, awarded the penalty of removal from services in terms of Regulation 4G of the Indian Bank Officer Employees Discipline and Appeals Regulations 1979. The appeal preferred by the petitioner before the general manager was dismissed by an order dated July 28, 1984, confirming the order of removal. The learned judge declined to interfere with the punishment of removal from service in view of the findings of fact on the charges made against the petitioner and dismissed the writ petition. Hence, the present appeal. Learned counsel Miss Tom Matthew, arguing on behalf of the appellant, submitted that this court has got jurisdiction to interfere even with the findings if there was no evidence or if the evidence available was perverse and that no reasonable person could have come to the conclusion on the basis of the materials. According to her, the irregularity, if any, established is only a technical lapse, and it cannot be stated that the petitioner had failed to discharge his duties with utmost integrity, honesty, devotion, and diligence so as to bring it within the meaning of misconduct under Regulation 3(1) of the Regulations 1976. She had taken us through the charges and the findings and submitted that the charges were not established and there was no loss to the bank. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.